Hello friends, welcome to EduSathi, your partner in education. In this video, we will be discussing the concepts of criminal law. So it's in the continuation with the criminal law 1 video. So let's start. The first concept we will be discussing in this video is the concept of abetment, which means to help. Abetment, the basic understanding of abetment is to help. Section 107 of Indian Penal Code defines abetment as a person abets the doing of a thing who first instigates any person to do that thing, instigates that person. So the concept of instigation comes into play. Second, engages in any conspiracy for doing that thing if an act or illegal omission that takes place in pursuance of that conspiracy and in order of the doing of that thing. Third is intentionally aids by an act or illegal omission by doing of that thing. So these are the three ingredients which are defined under the section 107. So let's understand the ingredients. Act includes an act or omission. They can be an act done or omission to do certain act. Second is instigating a person to commit an offense. You are influencing or persuading or instigating a person to do certain offense or crime. Engaging with one or more persons in a conspiracy to commit a crime, thereby one or more people come together in a conspiracy to commit a certain crime or offense. Intentionally aiding a person by an act to commit an offense. So you are helping a person who is committing an offense intentionally, that you know that person is doing offense and you are helping that person intentionally. So that results in commission of the offense. So these are the ingredients of the section of abetment under IPC. Let's take the problem. A principle is a person who by willful misrepresentation or by willful concealment of a material fact which he is bound to disclose voluntarily causes or procures or attempts to cause or procure a thing to be done is said to instigate the doing of that thing. So this is a new principle which is in addition to the principle we understood. This is the principle given in other terms. Explanation is a person abets the doing of the thing who instigates any person to do that thing. So the basic understanding is, explanation is that there must be an instigation to help, that would amount to abetment. The facts of the case are: Tejasvi, a public officer, is authorized by a warrant from a court of justice to apprehend Rashi. So she has come to arrest Rashi. She is a public officer who is given authority by court of law. Avinash, knowing that fact and also that Juhi is not Rashi, willfully represents to Tejasvi that Juhi is Rashi. So he intentionally causes Tejasvi to apprehend Juhi. So what Avinash did, he represents that Juhi is Rashi, but he himself knew that Juhi is not Rashi. So he instigated and intentionally caused Tejasvi to apprehend Juhi. Is Avinash guilty of abetment? Abetment means helping someone to do an offense. So in this case, Tejasvi has actually apprehended a wrong person, which is the offense. So is Avinash guilty of abetment or not? So let's take the options. A. Avinash will not only be held guilty. Avinash will not only be held guilty if Tejasvi will be able to successfully apprehend Juhi. No, this is not an answer, because Avinash has actually instigated. So all the ingredients of abetment has been fulfilled. So in this case, this is not the answer. Avinash will not be guilty because it was Tejasvi's duty to find out the reality. Yes, it was the duty of the person who had come as a public officer, but in this case, Avinash has actually instigated and caused her to believe that she was apprehending the right person. So this is not the answer. C. Avinash will be guilty because he instigated the apprehension of Juhi. Yes, this can be an answer. Let's take the last option to find out the right answer. D. Avinash will not be guilty, but Juhi and Rashi will be. Juhi in no circumstance would be held liable because she did not have anything to do with the wrong apprehension. So D is also not an answer. The right answer is Avinash will be guilty because he instigated the apprehension of Juhi by making Tejasvi believe that Juhi was Rashi. So the next concept we understand here is criminal conspiracy. Section 120A of Indian Penal Code defines criminal conspiracy as when two or more persons agree to do or cause to be done an illegal act or an act which is not illegal by illegal means. So there are two categories of acts which come into play. First is illegal act, so with the act which is inherently illegal. Second is act which is not legal. That means a legal act by illegal means. So herein the act is not illegal, but the means which are used to do that act are illegal. So two categories of things come into play, that is doing an illegal act or doing a legal act by illegal means. So such agreement is designated as criminal conspiracy. So when two or more persons come together to do an illegal act or a legal act by illegal means, so that agreement between such persons is called criminal conspiracy. Provided that no agreement except an agreement to commit an offence shall amount to a criminal conspiracy unless some act besides the agreement is done by two or more parties to such agreement in pursuance thereof. So it says that no agreement would amount to criminal conspiracy to commit an offence, provided that there must be some act. There should be some act done besides that agreement. So there must be certain kind of act other than the agreement which should be done in case of the agreement to commit a crime. So only then it would amount to criminal conspiracy, not otherwise. So let's take the ingredients. Agreement between two or more persons. So there must be two or more persons. One person cannot enter into a criminal conspiracy. So there must be more than two people. Agreement to do an illegal act. Mere agreement is sufficient for commission of an offence. So when you are agreeing to do an illegal act, in that case only an agreement is sufficient for commission of an offence. Agreement to do legal act by illegal means. This is the second category. Some overt act must be done to be committed by one or more parties to the agreement. So when you agree to do some legal act by illegal means, some wrongful act must be done in furtherance of that agreement. Otherwise, it would not amount to a criminal conspiracy. So the differentiation lies between the first and second category. In first case, there must be only an agreement would be enough to constitute criminal conspiracy. However, in the second case, there must be some overt act done. So this the part of some overt act comes into play. So the differentiation lies between these two categories of acts done. Next is section 124 Indian Penal Code, which defines sedition. Right? Sedition is a crime against the government of India or Indian sovereignty. So we'll understand what sedition means. Whoever by words either spoken or written or by signs or by visible representation or otherwise brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law in India. So the person must be intending to bring hatred or disaffection by all these kinds of representation, by words or by signs, by visible representation. So that person is intending to bring hatred or exciting hatred or disaffection against the government of India. Section further continues to the punishment to be provided for the offence. So the definition we need here is this much only. You can read the whole section by logging into the internet. So section 124 also 124A also provides for the punishment for sedition. So the definition I have taken out here is only the part which defines sedition. And the explanation here is the comments expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means. So any comments which are against the government, against their improper means, or of the administrative or other action of the government. So all the comments against the government and their actions which without exciting or attempting to excite hatred, contempt or disaffection do not constitute an offence under the section. So all the speeches given by the ministers or contending ministers in the elections against the other party, as in when they say that current government is not functioning properly, and there is inflation due to the current government's action, it's corrupt, or any other words used against the government, it is not amounting to the sedition. It does not amount to the crime of sedition. So all the comments of these kinds are allowed to be done if they are under the scope of constitution. So it is not a crime. So what are the ingredients of sedition? The expression of disaffection includes disloyalty and all the feelings of enmity which brings or attempts to bring hatred or contempt towards the government established by law. So there must be such words or such expression of disaffection which is attempting or bringing disaffection or hatred against the government of India in this case. So it would amount to sedition by any means, be it words, written words, signs, or visible representation. All those kinds of methods used would amount to sedition. Let's take a problem. Principle is the same. Whoever by words, signs, or otherwise brings hatred or contempt or excites disaffection towards the government established by law is guilty of sedition. Facts. Opposition leader Udhav Sen, in the middle of his speech in the public meeting, declared, "This government of cheats, scoundrels, bootleggers, and scamsters should be thrown out. They do not deserve to rule. Teach them a lesson by unseating them from power." Is he liable for sedition? So we discussed that the comments or expression of disaffection towards the government, which is bringing hatred, would amount to the offence of sedition. However, on the same side, we read in the explanation that all the words against the government and their inappropriate acts would not amount to sedition. In this case also, Udhav Sen is only giving the option of voting out the current government. He's not calling for any kind of armed rebellion or rebel against the state or the government of India. He's just giving the option of voting out the current government. So all the words used by him would not amount to sedition, right? So in this case, it's not an offense of sedition. Let's come to the next concept of culpable homicide. Culpable homicide and murder. Culpable homicide is defined under section 299 of IPC and murder is defined under section 300 of IPC, that is Indian Penal Code. So let's understand the culpable homicide first of all. Section 299 says, whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely by such an act cause death. So in this case, any person who is doing certain act and has the intention of causing death is doing such kind of bodily injury or has the knowledge that that injury might result into death. So there's a likeliness, possibility that it would result into a death. That all the actions done by all these ingredients would amount to culpable homicide. So it is different from murder, and we'll understand murder, then we'll see what are the differences between both the concepts. Murder, section 300 defines it as, first, if an act by which the death is caused is done with the intention of causing death. So in this case, the death is already done and there was the intention of causing such death. Secondly, intention of causing such bodily injury as the offender knows to be likely to be caused the death of the person. So here also the injury that the offender is under the knowledge that the injury which he is inflicting upon the person would result into the death of the person. This is the second ingredient. Thirdly, intention of causing such bodily injury as is sufficient in ordinary course of nature to cause death. So the concept which comes here is that that bodily injury which is inflicted upon the person, deceased person, was sufficient in ordinary course of nature. If you're cutting somebody's throat with a sword, that injury is sufficient enough to cause the death of a person in ordinary course of nature. In 99% of the cases, the person would die by cutting the throat with a sword. So this is the third ingredient. Fourthly, the knowledge that the act is so imminently dangerous that it must be in all probability cause death or bodily injury likely to cause death. So there is a knowledge that the act which is to be done is such dangerous, imminent danger is very very dangerous, and it must be in all probability that there are chances that in most the probability, and it would amount to an act which will result in death of the person. So the concept of murder is grave in nature and has broader scope, has the lesser scope, narrower scope as compared to culpable homicide, because the injury which is done in case of murder is more graver in nature. There is, so the difference where in the case of culpable homicide there is a likeliness of causing the death, right? If you are throwing a stone or throwing a brick on a person, there is a likeliness of causing the death of that person. That brick might hit some other place, it might hit his shoulder, it might just give him a fracture or something. It might not result in death, but there's a likeliness, because if it hits his head and he gets a brain hemorrhage or something, in that case it might result in death. But in case of murder, such injury is sufficient enough to cause the death of the person, and it's very dangerous in nature. Like we took the example of cutting somebody's throat with a sword. So the acts done under section 300 are graver in nature. They are much more dangerous as compared to the acts under culpable homicide. So there's a very thin line between these two concepts. However, the nature of act and the gravity of its nature would differentiate between the concepts, and the difference between culpable homicide and murder would be seen. The punishment which is given for culpable homicide is lesser than murder. So every defense lawyer tries his best for protecting his client by taking his case away from murder towards culpable homicide, so that punishment is lesser. So every defense lawyer would have the put in most of his effort to prove that it's not a murder but a culpable homicide. Let's take a problem. A person is said to commit the offense of culpable homicide if he doesn't act with the intention of causing death or with the knowledge that he is likely to cause death by such act. Facts: Ram knows Ravana to be behind a bush in the Millennium Park in Delhi. However, Lakshman does not know this. Ram induces Lakshman to fire at the bush, telling him that it would be fun to see hundreds of birds flying in the sky, creating a huge noise. Lakshman fires and kills Ravana. So let's decide who would be held liable for what crime. That is, whether that person would be held liable for culpable homicide or murder. In this case, the principle of culpable homicide is given, so this means we have to decide whether the person is liable for culpable homicide or not. First, only Ram is guilty of culpable homicide, as only he knew Ravana's presence behind the bush. So this can be an answer, because Lakshman did not know that there's a person sitting behind the bush. So Ram is the person who would be held liable, even if anybody has to be held liable for culpable homicide. B. Only Lakshman is guilty because it was his shot that killed Ravana. So there was no intention, no knowledge, no action done to cause such bodily injury that would kill Ravana, because there was no knowledge that person is sitting behind the bush. So this cannot be an answer. Lakshman cannot be held liable for culpable homicide. C. Both Ram and Lakshman were guilty. No, since we already discussed that Lakshman is not guilty. D. Both Ram and Lakshman are not guilty. No, because Ram is guilty of culpable homicide, since he instigated Lakshman to fire in the bush, knowing the fact that Ravan is behind the bush. The problem has been taken from the Bare Act of Indian Penal Code only by changing the names. So this is the case which is given in the Bare Act of Indian Penal Code. In this case, only Ram is guilty of culpable homicide. Next thing we need to discuss here is section 304B of Indian Penal Code, which gives the provisions for dowry death. Let's understand. This is the bare wording. Where the death of a woman is caused by any burns or bodily injury or occurs otherwise than normal circumstances. So this whole line says the death must be caused under abnormal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand for dowry. Such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death. So this is the concept where a woman dies of any burns or bodily injury within the 7 years of her marriage, and it is proved that immediately before her marriage there was a proof that there was a cruelty or harassment by her husband or any other relative. So that person would be deemed to have caused her death even if the circumstances say otherwise. So there's a reverse burden of proof. We discussed the burden of proof is upon prosecution. However, in case of dowry death, it's upon the defense. The defendant has to prove that they have not caused her death, because the section itself provides they will be deemed to have caused death. In all the circumstances, if the woman dies within the 7 years of her marriage and there's a proof that she was tortured for dowry, so in that case the defense will be deemed to be the guilty of causing her death. So the defense has the burden of proof. There are only few sections where there is a reverse onus of proof, or burden of onus is burden of proof. So in this case there is a burden of proof upon defense to prove their innocence, because there the prosecution does not have to prove their guilty. The section itself gives the power to the court to deem that they have caused her death. Death caused by bodily injury or happens otherwise than under normal circumstances. There must be some abnormal circumstances involved in the death of the woman. Within 7 years of her marriage, we discussed that it should be done within this section would apply if the deemed provision would apply if the death has occurred between the 7 years of her marriage and must have been subjected to cruelty or harassment by her husband or relative. There must be some subject of cruelty or harassment to the woman who died. The harassment should be in connection with the demand of dowry. So there must be the connection of dowry, demand of dowry, to the cruelty or harassment, and meted out soon before her death. So it should be meted out immediately before her death. The husband or relative is presumed to have killed that person. So this is the section which provides for the provisions of dowry death, and this was added to Indian Penal Code after the amendment. So this is the section of dowry death. Next two concepts we need to discuss is wrongful restraint and wrongful confinement. Section 399 and section 340 of Indian Penal Code. Let's take the problem straight away, because these are the very simple concepts. This is A and he wants to go to the place X. However, C obstructs his way by putting an obstruction and stops that person from going to place X, which he has a legal right to go, right? So wrongful restraint means creating an obstruction and preventing a person from proceeding in any direction, in a one particular direction where that person has a legal right to go. For example, he wants to go to a fair. Everybody has the right to go to fair. C obstructs his way and prevents him from going to a fair. So in this case, this would amount to a offense of wrongful restraint, right? So this is an obstruction to prevent a person from proceeding in a particular direction. So what does a wrongful confinement mean? This is A and C prevents that person into a particular building or particular limits. So it's a prevention of a person from proceeding beyond certain limits, right? So this is a offense of wrongful confinement where a person is confined within certain limits. So C is guilty of offense of wrongful confinement of A, right? So the difference between these two things is In first case, a person is prevented from moving into a certain direction, but he can go anywhere else. He can go to this place or this place, this place, or any other direction. He's not prevented from going anywhere else except to the place X. However, in this case, A is stopped from moving in any direction. He's confined between these, marked limits. So in this case, it's a wrongful confinement. So this is the basic difference between the two concepts. These are the bare wordings given in the Indian Penal Code. Wrongful restraint: whoever voluntarily obstructs any person so as to prevent that person from proceeding in any direction in which that person has a right to proceed is said to wrongfully restrain the person. These are the bare wordings. You can read it by pausing the video or from the Indian Penal Code itself. This is the bare wording for wrongful confinement, which we have already explained. It says, whoever wrongfully restrains any person in such manner as to prevent that person from proceeding beyond certain circumscribing limits is said to wrongfully confine that person. There's an exception to the rule of wrongful restraint. It says, the obstruction of a private way over land or water which a person in good faith believes himself to have legal or lawful right to obstruct is not an offense within the meaning of this section. If the person believes, in the previous example, if the person believed that fair where the place X is owned by him and he's preventing A from moving in that direction, in that case it would not amount to an offense because he had in good faith believed that he had the lawful right to obstruct that person to enter his private property. So if he believed that place X belongs to him and he's preventing A from moving in that direction, and then in that case it would not amount to wrongful restraint. Let's take the problem. Principle: wrongful restraint occurs when person's movement is barred in all directions. Explanation: wrongful restraint would occur if the person cannot leave the restricted limits. It's in fact wrongful confinement. Let's just change it here. It's a wrongful confinement. The definition is for. So everywhere where wrongful restraint is used, you just presume that it's a wrongful confinement. Facts are: Lord Callaghan made a maze which ensured that even the best mathematical genius would need to put immense thought into negotiating his way through it. He put his wife into it, who could not negotiate her way from point A to B connected by a straight line in everyday life. His wife filed a case against him of wrongful restraint. So decide wrongful confinement in this case. So decide. Let's take the options. So in this case, the person has filed a case of wrongful confinement. We'll stick to wrongful confinement because the definition is for wrongful confinement and not wrongful restraint, and we'll decide accordingly whether it's a wrongful confinement or not. Let's take the options. Lord Callaghan is responsible for false restraint of his wife. Cannot find a way out of the maze in a question given her directional inability. This says that she was, the facts say that she has a very inability. She has an inability to take directions. So, since he knew that she had directional inability, even then he had put into the maze. So whether it would amount to false restraint or confinement in this case or not. No, because the person is not restricted into the premises. She can actually find her way out. She is not completely restrained. There is no complete confinement. There are no prescribed limits. It's just a maze. She has to find her way out. So she cannot succeed in the case of wrongful confinement. So this is not the answer. Lord Callaghan is not responsible, as putting into the maze does not amount to false restraint. So this can be an answer. It's a maze, not a circumscribed limits, which would not amount to wrongful confinement. C is: Lord Callaghan is responsible as the movement is not open in any particular direction but requires his wife to move from one direction to another. No, this is not the answer. D. Lord Callaghan is responsible as such restraint of ability to move amounts to cruelty, and keeping in mind the extra duty of care he owes to his wife, he is responsible for false restraint. No, this is not the answer. The definition of wrongful confinement is not applicable to this option. So the only answer left out is that he is not responsible, as putting into a maze is not false confinement or wrongful confinement, since there is a way out which he has to find out. So he cannot be held responsible for wrongful confinement. Next concept we need to discuss is Section 361 of Indian Penal Code, which defines kidnapping. So this section provides whoever takes or entices any minor, so there must be a minor, or any person of unsound mind. Next is it could be he could be of unsound mind, out of the keeping of lawful guardian of such minor or person of unsound mind without the consent of such guardian, is said to kidnap such minor or person from lawful guardianship. Guardian is the person who is the keeper of that person, and a parent or relative who is given the responsibility of taking care of that minor or the person of unsound mind amount to the person of being lawful guardian. Note, this section does not extend the act to the act of any person who in good faith believes himself to be the father of illegitimate child, or who in good faith believes himself to be the entitled to lawful custody of such child, unless such act is committed for a immoral or unlawful purposes. So if a person under good faith believes himself to be the father or lawful custodian of that child, takes that child away from the custody of other person, is not said to be committing the offense of kidnapping. However, if it's done for immoral or unlawful purposes, in that case this exception would not be available. So ingredients of kidnapping are: there must be a minor. The minority, if the definition does not provide, the minority would be female under the age of 18 years and male under the age of 16 years. If the section provides that it would be considered 18 for both the genders, in that case the principle given would be applied. However, if it's not given, it would be female under 18 years and male under 16 years. Taking does not imply force, simply means to go and escort. There is no need to prove that force was used. The enticement, there's the concept of enticement used. Only the enticement to go or escorting the child to come with the person would also amount to kidnapping. Enticing is persuading by offer of pleasure or some allurement. If you take away the child in the allurement of a chocolate or something else, or taking that child to some amusement park or something, in that case it amounts to enticing. The tricky area is intention is irrelevant. If you are doing such act of enticing or taking away the child from the custody of the lawful custodian without the person's consent, that would amount to kidnapping, even if there was no intention to kidnap, right? So the intention in the case of kidnapping is irrelevant. Next is abduction under 362 of IPC. Abduction is kind of similar with the concept of kidnapping. However, kidnapping applies to only the minors. Abduction, we will discuss, would also amount to the person, a major or a minor as well. So it is applicable in the case of both major and minor. So the bare wording says, whoever by force, so there's a force, or by deceitful means induces any person to go from any place, is said to abduct that person. So there is the case of force used or deceitful means used for inducing a person to go from any place. In that case, it's an abduction. So the ingredients are forcible compulsion, that is actual use of force must be there, or inducement by deceitful means, that is misleading a person by making a false representations, or a person could be either a minor or a major. So the section of kidnapping applied only to the minors. However, abduction is applied to minor as well as the majors. Force and deceit. So there's you can say that intention can be implied from the use of force and deceitful means. All both the concepts actually imply the wrongful or malified intention of the person. So there is no clause given for the intention of the person. It's implied from the action of the offender. Let's take the problem. principle, whoever takes or entices any person out of the keeping of the lawful guardian of such person without consent of such guardian is said to kidnap such person. So this is the kidnapping principle. Explanation: taking means to go or to escort, enticing means persuading by offer of pleasure or some other form of allurement. So if they have given the concept of enticing in detail, so this means there would be enticement involved in the facts. Let's go to the facts. A fell in love with B, who was prohibited by B's father F from contacting B. So there are three parties involved, A and B, who are in love with, but B is prohibited by F, that is B's A is prohibited by B's father F from contacting B. A, through his friend C, the fourth party comes in, sent a message to B to run away from her house as A would keep her in material luxury and comfort. So there is a allurement which is in the message. C convinced B that A's offer was once in a lifetime opportunity, as not everyone gets the person who loves them so much. B decided to leave F's house and go with A. C is prosecuted for kidnapping B. So let's decide. So the complication here is that who had enticed B from leaving the house. So in this case, although A had sent a message, but the actual action of enticing was done by C, because he is the one who convinced B with the offer that the offer given by A is a lifetime opportunity, and the person, not everyone gets the person who loves them so much. So in this case, the actual act of enticement is done by C. So let's decide who's guilty of kidnapping. First of all, A option says C is not guilty as it was A who in the real person behind the whole scheme. No, because he did not indulge into the act of enticement, because he did not personally enticed B. C is not guilty as A who it is A who actually enticed B to leave F's house while C was acting just as a messenger. No, we discuss this is related to the A option only. Let's take the next option. C is not guilty as B decided to leave the house of F of her own free will and she was not forced to leave. No, there was the enticement, as the facts clearly say that C convinced him. The use of word convince means enticement and making her believe the facts which are said by C. Last option left out is C is guilty as it is C who actually enticed B to leave F's house. So this is the right answer because he is the person who indulged in the whole action of enticing by convincing her that she must leave her father's house, because the opportunity given by A or the offer given by A is a once in a lifetime opportunity. So C would be held liable for kidnapping B. Section 425 Indian Penal Code defines mischief. So let's discuss the concept of mischief. The bare wording says, whoever with intent to cause or knowing that he is likely to cause wrongful loss or damage to the public or any person, causes the destruction of any property or any such change in the property, in the situation thereof, as destroys or diminishes its value or utility, affects it injuriously, commits mischief. So this means this is an act of destroying or diminishing the value of the property or its utility by causing the destruction or change in the property, which will result in loss or damage to public or any person. So the ingredients of mischief are: it is not essential to the offense of mischief that offender should intend to cause loss or damage to the owner of the property injured or destroyed. So the intention to cause damage to the owner of the property is immaterial. So if there's no intention to cause such damage, it would not be material in the offense of mischief. It is sufficient that he intends to cause or causes that is likely to cause wrongful loss or damage to any person or injuring the property, whether it belongs to that person or not. So the intention to cause damage to the property must be there, whether it belongs to that person or not. So the only intention behind this mischief, the concept of mischief, should be the wrongful loss to one person, or to the person by injuring the property. So there's a intention to cause damage to any person by injuring any property, whether it belongs to that person or not. Affects the property negatively. Such action of causing damage affects the property negatively and lowers its value. Mischief may be committed by an act affecting property belonging to the person who commits the act, or to the person, or that person only, or others jointly. So mischief can be done by the person who's committing the act to his own property also, or some other person's property. So if the person is burning his own property in order to actually cause damage to person X, in that case it would amount to mischief, even though he is actually damaging his own property. So the concept of mischief does not require the ownership or the owner of the property. It's upon the person by causing the damage of the property, whoever may be the owner of the property concerned. Let's take the problem. Principle: mischief is the injury to the property with the intention of causing wrongful loss to any person or public. The person to whom the loss is wrongfully caused by mischief need not to be the owner of the property himself. Facts: Amar has leased his house to Akbar for 5 years. After 1 year, Amar requests Akbar to vacate the house, but later refuses. Amar, in order to get Akbar vacate the house, causes fire to it. So in this case, he has caused fire to his own property in order to cause harm to Amar. But Akbar, with the help of neighbors, quickly extinguishes the fire because it could really damage the property. Is Akbar liable for mischief? Yes, definitely. This is the clear-cut case of mischief because he wanted to cause damage to Akbar by putting fire in his own property, and later he is actually extinguished the fire immediately because it could cause damage to his own property. So this is the clear-cut case of mischief. Yes, he will be liable for mischief. So this is the case of mischief in the clear circumstances. So thank you for being with us.